Is being recorded.
And we are live and recording in 23J366.
Okay, thank you. Good morning, everyone. Welcome to the single justice session of the appeals court. I'm Justice Shin. Before me today is one matter. It's 2023 J366 Bristol County Homes Inc. versus Stephen. Is it Duarte, Attorney Russell, or Duarte?
Duarte, I believe, Your Honor.
Duarte, okay. And this is a motion to waive an appeal bond. And Attorney Russell, this is your motion, so you may proceed. And just so you know, I have read all of the papers, so I'm aware of the background of the case and the issues. All right, so whenever you're ready, you can start.
Thank you, Your Honor. May it please the court, Glenn F. Russell Jr. on behalf of the appellant, Stephen Duarte. As Your Honor has referenced, she has read the record, and the issue in this matter is solely the housing court judge found that the defendant was indigent. So the sole basis for the denial was the housing court's ruling, finding that any appeal would be frivolous. And the defendant's position on that, Your Honor, is this involves a statutory construction of GLC 244 section 35C, specifically subsection B of that statute. There's been no case law that I'm aware of that's actually parsed that language. And I identified to the housing court judge in the summary judgment opposition, specifically at pages 49-50 of that opposition. I went through the language of that statute, and while a cursory review of that may indicate that that certifies conclusive compliance with GLC 244.14, reading the language, it does not say that. It says the failure to comply. Specifically, the section that talks about provided that. So there's a second section to that statute, and it says, first time having used these, provided that an arm's length third-party purchaser for value may rely on such affidavit, talking about the 244.35C affidavit, it shall not be liable for any failure of the foreclosing party to comply. Now, comply refers to the filing of the affidavit, and it says
right, but the clause before says that the affidavit is conclusive evidence, not just compliance, but that the mortgage is entitled to proceed with foreclosure.
I agree, Your Honor, but that second sentence, it says, quote, provided that, and it says provided that, and it talks about shall not be liable for any failure of the foreclosing party to comply, and title to real property thereby shall not be set aside based upon such failure, right? So it's not that it's not certifying compliance with 244.14. And the reason why, Your Honor, is that would seem to indicate that that would be a denial of due process. So the borrower has a 3-year right to challenge the foreclosure under GLC 244.15 subsection C and subsection D.
Right, but why is it a due process issue as opposed to just purely a statutory issue? Because I mean, your client could have brought this issue about the note prior to the foreclosure sale, right?
Could have, but it was a non-judicial foreclosure sale, Your Honor.
Right, but I mean, there could have been an action brought prior to the foreclosure sale. So that may, I guess I'm just not seeing it as a question of due process, because it seems like 35C, insofar as it says this affidavit's conclusive evidence, it applies only after there's been a purchase by a third-party purchaser.
Right, and the defendant takes this language as to an uncontested foreclosure, right? If it was uncontested, that would be. But here, because they have a 3-year window to contest the foreclosure, Your Honor, they don't have to do it prior to the auction. 244.
No, I understand, but you raise it in your motion, or at least the request for review, as a due process issue. I'm not seeing how it's a due process issue when there were remedies available to your client prior to the sale, the purchase. So putting aside the due process issue, I understand what you're saying about the statutory issue, about section 15. There's a 3-year window, but let me ask you this.
Okay.
I mean, I think it's an interesting question how 35C, what the interplay is between 35C and section 15. But the plaintiffs here have put in the deed and the section 15 affidavit, plus a copy of the notes, 5C affidavit. Seems to me to be clear that they've made a prima facie case. And the court has said, this court and the SJC has said, once the plaintiff has made a prima facie case, the burden shifts to the defendant to put in an affidavit or some other evidence that would be admissible at trial that creates a genuine issue. So tell me where in the record can I find that?
Well, and Your Honor, the defendant's position is that under Bartleman, the defendant's saying that they didn't meet that burden. And the reason, Your Honor, this is the second part of the argument about 35C. The SJC in Eaton, 462 Mass 569, note 28, the SJC stated specifically what type of affidavit was required to show that they had the note. And that was under GLC 1835B. So that ruling would pertain to foreclosing entities' requirement to show they have the note. This statute was directed at third-party purchasers, right? So that's why the language we say in here, when they talk about complying with 35C, not 244.14. And the SJC, and they say that that was the affidavit to be filed.
But I mean, let's put aside 35C for now. It doesn't the affidavit filed under section 15 plus a copy of the deed satisfy the plaintiff's prima facie case as to their right to possession? And so if that's true, and that's what the SJC has said, and that Bartleman doesn't say any differently, where is the evidence that rebuts their prima facie case insofar as the issue you're raising now, which is whether they had the note?
We again, and I respectfully, I don't want to beat the dead horse, but the defendant's argument is that they never made that burden because they didn't make the showing as required under Eaton at note 28.
Eaton note 28. So tell me what Eaton note 28 says.
Eaton at note 28 says, and it also shows that the affidavits are, not definitive. It says that it says at least with, I'm doing this from memory, at least with regard with unregistered land, which this is, a foreclosing entity, I'm paraphrasing, I don't have the exact wording, can supply an affidavit under GLC 1835B. And such affidavit, because can show compliance that they were in possession of the note. And it cites the GLC 18354B.
Wasn't section 35C enacted after Eaton?
It was, but
it says it's conclusive evidence. I understand your position that maybe conclusive doesn't mean conclusive, but it's certainly admissible evidence. I can get a statute that says it's conclusive evidence to mean it's not even admissible evidence. It's admissible evidence.
No,
it's prima facie evidence. So I'm going back to my question, which is what did you put in to rebut that showing? Assume that it is a prima facie showing. Just assume that. I know you disagree. What did you put in to rebut that showing?
But that's the argument, Your Honor. The argument is that it's not prima
I know. I'm asking you to assume that there is enough here to make a prima facie showing, and I want you to correct me if I'm misunderstanding and missing something in the record, that there's nothing in the record to rebut that prima facie showing, that your argument is purely a question of statutory interpretation.
Well, and it also goes to, Your Honor, while it may be admissible, Your Honor's aware under the Wingate decision we could look at the weight of that evidence. And also in the argument was the evidentiary sufficiency of that document itself, the affidavit, which refers to unidentified business records. I
So
noticed
the answer to my question is there is nothing in this record I will be able to find that rebuts the prima facie showing. If assuming there is a prima facie showing.
but then
Is that correct? I just want to make sure I'm not missing something in the record. If you want to point me to something in the record, I'll look at it.
but again, Your Honor, that denigrates the appellant's argument that they did not make a prima facie case.
I understand your argument. Okay.
So again, that it kind of puts the defendant in, making an argument that he did want to advance. He's stating that they did not meet that burden based on the statutory language in the SJC instruction.
I understand the argument. What I'm trying to get you to answer is, assuming I were to disagree, is there anything in this record that rebuts, I'm assuming right now, to be a prima facie showing?
We have to stand on the record, Your Honor. That's the argument.
All right. Do you have anything else?
No, I very much appreciate the indulgence, Your Honor.
Okay, thank you. Attorney Merritt.
Yes, Your Honor. Thank you for the time this morning. So I have a simple mind. So let's just kind of back out a little bit, right? What we're talking about here fundamentally is the larger macro issue of, did the foreclosing mortgagee hold a note, or was the foreclosing mortgagee the authorized agent of the note holder at the time of the sale in November 2021? Fundamentally, that's the question we need to ask. This is de novo review, right? And so I think it's important to note here that the summary judgment record, and this was put before the housing court in the context of defendant's motion to waive the appeal bond, on that note holder issue, including the 35C affidavit, yes, and I'm going to get to that in a moment. But more directly to the point, the record before the trial court included an affidavit from attorney Mark Levin. Who's Mark Levin? Mark Levin was the closing attorney that conducted the closing for plaintiffs when they purchased the property. He's a title insurance agent. As part of his representation, he had to make sure that the deed into the plaintiffs was insurable, marketable, all that fun stuff. As part of that, because the property was being acquired through a foreclosure sale, he had to investigate, amongst other items, did the foreclosing mortgagee comply with 244-14? He reaches out, and this is all in his affidavit. He reaches out to the firm that conducted the foreclosure sale, DeMare Hoger, says, hey, can you please send me a copy of those Section 14 notices? They send those notices over. Now, the relevance of those notices, Your Honor, is a couple of things. This is going to get to some of the things Your Honor was asking my brother about. Those notices, which are attached, I believe, as Exhibit H to the affidavit of Mark Levin, those notices include the Section 14 notice that was sent to the defendant on October 21st, 2021. Attached to that notice, very crucially, is a certification pursuant to 209 CMR 18.21. We'll just call it 18.21A from now. There's a lot of, parentheses, so on and so forth after that. That provision, that code of the Massachusetts regulation, is basically can be thought of as a belt and suspenders approach to a 35C affidavit. And what that requires is for the servicer to certify, to the mortgagor in connection with the notices of sale going out, well, how does the foreclosing mortgagee, what's its relationship to the note? What's its relationship to the mortgage? There has to be some certification of that. That certification establishes that the foreclosing entity held the note. It also included, it included a copy of the note, a redacted version, of course, but it included a copy of the note, included a copy of the assignments. That notice was sent, and this is also in Attorney Levin's affidavit, that notice was sent and received by the defendant on or about October 26, 2021. Now, the relevance of this is twofold. Number one, Your Honor was asking about, due process concerns. How come the defendant couldn't file something before the sale, so on and so forth. He received the notice. He had a copy of the note at the time. He knew the inning in the score. And I say that only by way of saying, I could see a mortgagor saying, well, I didn't know the 35C affidavit was recorded. Okay, fine, fair enough. But you received, here in this case, we have facts that establish you received a copy of that 209 CMR certification. You knew the ending in the score that the foreclosing mortgagee was claiming to be the holder of the note at that time. So not only does that kind of resolve the procedural due process concerns, he knew he could have filed an action. The courts they're open to all members of the public. He didn't do that. But more to the point, that macro issue we're analyzing here, that Eaton issue, this also establishes, that prong of the standing to foreclose analysis. Now, the housing court admittedly didn't get into this point in the memorandum of decision on summary judgment or in its decision on defendant's motion to waive the appeal bond. But this evidence was in the record on summary judgment. It was further in the record as part of the opposition. Yes, Your Honor.
It was a she, right?
Yes, Judge Chapman.
She seemed to say that under 35C, this was conclusive evidence in the sense that
Yep.
the defendant was not allowed to put in anything to rebut it. It's conclusive. Would you agree that there appears to be a conflict between Section 35C and Section 15?
I don't. I don't agree with that because when the court is using that specific term conclusive, it's just cherry picking, admittedly. It's plucking that term out of the 35C affidavit, 35C, the statute. Now, that statute, let's just kind of, briefly walk through it because I feel like, with all due respect to my brother, he's twisting the analysis into a complicated pretzel when really the statute's pretty basic and simple. And Your Honor sort of alluded to this in its remarks. Essentially, what that decision does is it codifies the Eaton decision. That's really all the statute does. And what it says, the first line of it, paraphrasing, of course, but what it says is creditor, foreclosing mortgagee, shall not publish a foreclosure notice under, shall not take any action under Section 14 unless it's the holder of the note or the authorized agent of the note holder. Pretty basic. Again, codification of Section 14. It then says, puts a further requirement. The legislature says, okay, how are we going to ensure that, these foreclosing entities comply with this rule, this Eaton rule in this provision in the statute? I got it. We're going to have them record an affidavit. And that's what the next sentence says. It just talks about an affidavit. Again, very basic and straightforward stuff here. And then it gets into the part that's most relevant here about third-party purchasers, bona fide purchasers, as I refer to it in this matter with respect to my clients, the plaintiffs. And again, the language of the legislature, very clear. This isn't, David Merrick giving a spin on it or anything like that. This is, the affidavit certifying compliance with this subsection shall be conclusive evidence in favor of an arm's length third-party purchaser for value that the creditor is fully complied with this section. The mortgagee is entitled to proceed with foreclosure. That's extremely straightforward language. There's zero ambiguity there. So what the legislature allowed my clients rightfully to do is look at that affidavit and say, all right, we're relying on this. Again, that's the legislature's authorizing them.
But are you saying it means what the judge seemed to think, which is that once in a court action, it means that the defendant cannot, it's conclusive evidence as to the underlying issue as to whether the
it's conclusive evidence. So it is conclusive evidence. However, and this is crucially important because this sort of gets back to the procedural due process question. At the end of the day, with respect to third-party purchasers for value, the question is, was the sale void? If it's voidable, no big deal. But if it's void, that's an issue even for third-party purchasers for value. The court was asking in its remarks to my brother, okay, they meet a prima facie case, the burden then shifts back. You have to then rebut that. Where in the record is there specific evidence of that? I would say, in response to Your Honor's question that Your Honor just asked a moment ago, that's the point in time where they need to submit an affidavit directly rebutting the evidence in here,
Okay.
in this case, the
You're-
micro
you're-
issue is,
You're agreeing that they're still entitled to do that.
of course, I mean, that's the standard that Bailey sets, that Hendrick sets, and, the litany of cases from this court and other courts in the Commonwealth. But again, and this kind of gets me to another point I wanted to raise, at that point, when the burden shifted, the court asked probably 4 or 5 times, where in the record, because that's the operative question, right? The short answer is they didn't do anything. And I don't just say that to be flip. Their argument was, well, the plaintiffs haven't established that the foreclosing entity held the note. That was quite literally their argument. To which we said, well, yes, we did establish that. We went outside the context of 35C. We got an affidavit from Mark Levin. We included a copy of the foreclosure notices that were sent under 244, Section 14. That included the 209 CMR certification. And at that point, between the affidavit, the 35C affidavit precisely, the language therein, and the 209 CMR certification, we said, we have carried the day on this issue. You have failed to rebut it. And that fundamentally was our argument at the trial court. And similarly, the argument in opposition to the motion to waive the appeal bond.
Okay.
And so really, that's basically, the sum of my argument. I know Your Honor's read the papers. And if the court has any specific questions, I'll be happy to address those. But otherwise, I don't have any further remarks.
No, I think I forgot to ask you a question, Attorney Russell. Has your client made the payment that the court ordered for July 15th? You're on mute. Can we unmute?
I've asked Attorney Russell to unmute himself, yes.
You're still muted. Okay,
I apologize, Your Honor.
no worries.
Apparently my client attempted to make that payment, and my sister, Attorney Ethier, may have a supplemental statement on that, but he unfortunately misidentified the payee, and Attorney Ethier contacted me, I believe Friday afternoon, late Friday afternoon, to tell me that, and I reached out to my client to re-execute the payee line for the correct payee.
Okay.
She didn't receive the check though, or was in receipt of it.
Okay. Did you want to add anything, Attorney? Is it Ethier? You're on mute.
Unmuted.
I think it's the because you have the video going on a separate device. Attorney Merritt, did you want to add anything to that?
I think Attorney Ethier is having some technical difficulties, but my brief understanding is that there was an attempt to make the payment. Long story short, we'll get it sorted out. Okay. If we're talking about discrepancy over the payee, I mean, the world will go on and we'll figure that issue out. It's, I think there was an effort to pay it. Great. And if it's a payee discrepancy, we'll get that sorted out.
All right. Okay. Okay. Thank you. I will take it under advisement, and you will get a decision promptly.
Thank you
Thank you very much, Your Honor, for your time this morning.
Have a great